Joe Norman, Tallahassee, Florida. Thank you for convening this hearing. Hopefully today we will open America's Pandora's box and address issues with the federal judiciary that have simmered for decades. Since the Founding Fathers signed the Constitution of the United States, there's been a long history establishing the rights of citizens to present evidence of corruption to a grand jury for review. Indeed, Congress made clear this right when it established 18 U.S.C. 3332, mandating a U.S. attorney to take evidence of corruption in the district for a special grand jury for review. The U.S. Attorney Criminal Resource Manual, Section 158, has language similar to 3332. A federal judge in the Southern District of New York interpreted 3332 and determined a U.S. attorney has no discretion when a request to comply with 3332 is made. He shall perform as requested. The United States Supreme Court has concluded in numerous decisions the right of a citizen to have grievances heard by a grand jury. This court has also made it clear that codified law must be adhered to unless it is considered absurd or is not clear. I've tried for years to have 3332 enforced and to have evidence of corruption in the federal courts of the Southern District of Florida and the 11th U.S. Circuit Court of Appeals presented to a special grand jury. In my years of trying, no agency has demonstrated any desire to evaluate and comment on my evidence or indicated what is absurd or not clear in the language found in 3332. My evidence consists of depositions which show defendant attorneys misrepresenting facts to the courts that were diametrically opposed to their client's testimony. In office of the court handling of my civil case, there was rampant abrogation of the canons of judicial conduct that were in effect for the time of litigation and the model code for lawyers. During the saga of my civil case through the 11th Circuit, there was zero comment by the defendant lawyers or courts on any evidence or decisional law that supported my complaints. And there was a lot. This officer of the court conduct should reasonably result in indictments on numerous charges by a special grand jury. The Congressional Oversight Manual on the summary page mentions the need for Congress to ensure laws it passes are complied with, and that is all I want. Codified law complied with, and those who refused held accountable. Attorney General Holder's mentioned in numerous speeches, both domestically and internationally, that America has the rule of law and is a nation of law. Unfortunately, these concepts were apparently not made known throughout the Department of Justice, as the Department of Justice Office of Professional Regulation, FBI, Inspector General, and even Holder, who I sent communications to, declined to enforce codified law as I requested, or even want to review any of my evidence. It seems to me there are violations of obstruction of justice, 18 U.S.C. 241, 242, and other laws. There's a concept in our country that no man is above the law. Please confirm this receipt and have conduct of numerous people in the Department of Justice and officers of the court and the 11th Circuit reviewed by professional presentation to a grand jury for criminal indictments. There's a declaration over the entrance of the Supreme Court building that says equal justice under law. To that I say, really? The authority to self-police as the federal judiciary does not work, and I'm an example. Thank you for your time.